is Zoom. Says it's in progress.
You have the right one. I didn't have the link. I had to ask Wendy for it.
I'm on it. I have it. Shows 7 participants. 1, 2. I think that's everybody. Y'all all want in?
Oh, it's nice.
Have a choice. Where's the button? Oh, should we let Mindy in?
Yes.
Well,
Do we have everybody?
can you hear me, Judge?
I can hear you.
Okay, it says Patty McRae Steinke. This is Ted. It's my wife's computer.
Okay. Yeah, it doesn't have your picture on there, but that's all right.
Yeah, for some reason, you want me to try to get back in?
I don't care if you want to.
That's okay. Okay, there we are.
Yeah, there you go. All right, this is 003833552020 State Texas versus Joshua Michael Hurd. I think we're here on a state motion to hold bond insufficient. Is that right?
Judge.
Yes.
Okay. And I guess you can offer whatever you wish to offer.
Yes, Your Honor. State is not going to call any witnesses, but we are going to offer states exhibits 1 through 9. I will start with 1 through 3, which are the certified copy of the bond conditions and a certified copy of the protective order. States exhibit 3 is the certification from the district clerk's office that it's a true and correct copy of the protective order. So at this time, state would offer 1 through 3.
No objection.
Okay. They're admitted.
Thank you, Judge. So I'll just go ahead and start with those exhibits. In states 1, I would ask Your Honor that you take note of bond condition number 1, which says no contact with the complainant in this case. And also take note of bond condition number 5, which is that he not be alleged to have committed a new offense in the state of Texas.
Okay.
Finally, on those bond conditions, I'd ask that you take note that they were signed on May 1st of 2020.
Okay.
In States Exhibit 2, that is a copy of the protective order. And in that protective order, I'd ask that you take note on page 2 of the protective order, paragraph G, where it says that the defendant is prohibited from communicating in any manner with any protected person except through his attorney, and the protected person being Alicia Hurd. And in paragraph H in the protective order, it also states that the defendant is prohibited in engaging in any conduct that is reasonably likely to harass, annoy, alarm, abuse, torment, or embarrass the protected person. And finally, on page 5 of the protective order, state would like to point out that that protective order is in place until June 5th of 2030. And at this time, state would offer states 4 through 9. Defense counsel has been provided a copy of these. It's my understanding through our communications that he is stipulating to them. Those are the attempts to communicate with Alicia Hurd.
That is correct, Your Honor. We will stipulate to those and no objection.
Okay. 4 through 9 are also admitted.
Okay. And I will go through those as well, just briefly. States 4 is a text message from the defendant to Alicia Hurd's stepdad, Bob, asking to speak with Alicia, and that was sent at 7:30 p.m. on Friday, July 31st of 2020. States Exhibit 5 is 2 texts from Josh to Alicia Hurd's mother, Susan, stating, Susan, it's Josh. I have an emergency. Is there a way I can talk to Alicia, please? The second text says, please, I'm sorry for all the trouble I caused. I love her so much. I have no one else to turn to, please. Those were received by Alicia's mother on July 31st at 8:00 p.m. States Exhibit 6, it's a little difficult to see, but it shows a call from Joshua Hurd to Alicia parents' landline. States Exhibit 7 is a screenshot of a missed call from Joshua Hurd to Alicia's mother, Susan, on July 31st at 7:36 p.m. to her cell phone. States Exhibit 8 is a voicemail message. Your Honor, I believe that you've already listened to it. It was left on Alicia's stepfather, Bob's cell phone, asking to get in touch with Alicia. And finally, States Exhibit 9 is screenshots of 2 emails sent directly to Alicia from Josh on July 31st of 2020. The first email states, I'm sorry to bother you. I have nowhere to turn. Can you please help me? And the second email states, please, I'm sorry, baby, it's an emergency. And that concludes the state's exhibits.
Okay. Anything else you want to offer?
Nothing further from the state.
All right, you rest.
Yes, state rests.
Does the defense have any evidence?
I'd like to call my client, Joshua Hurd.
Okay, if you would raise your right hand and be sworn. You swear or affirm testimony about giving this cause to be the truth, the whole truth, nothing but truth, so help you God.
Yes, sir.
All right.
Okay, Joshua, on July the 31st, you sent 2 text messages to Alicia's parents using the word emergency. In the voice message that the judge has heard, you used the term emergency. And in one of the 2 emails to Alicia, you used the term emergency. What was the emergency?
Well, I was locked out of my hotel room where I've been staying, and I'm on medication to get better, and it was locked in the hotel room, and I just needed like a night or 2 worth of rent before I got paid. So I ended up sleeping outside that night, and I was needed to take my medicine, so that was the emergency.
Okay, and you were calling Alicia or trying to get a hold of Alicia to see if you could borrow some money from her for your rent?
Yeah, I don't really have anyone else.
Okay. You did not attempt to go to her residence.
No, sir.
You did not attempt to go to her place of employment.
Not at all. No, sir.
Okay. And you were not threatening in any of these, were you?
No, sir.
You were pleading with her.
Yeah, I was just in a bad spot, and I just needed some help.
What kind of medication do you take?
It's serotonin blocker for anxiety and depression.
Okay. And you have not, in the 2 months since the protective order was issued, you have not attempted to contact her at any other time other than this one time when you were locked out of your motel room?
Correct. I haven't talked to her. I haven't received text, nothing.
Okay, thank you. I'll pass the witness.
Any questions?
Yes, Judge. Mr. Hurd, when you posted bond on May 1st, 2020, you were aware that you were given bond conditions.
Yes, ma'am.
Okay, and you were aware that one of those conditions was no contact with the complainant in the case?
To be honest, I was not. We spent the next 2 weeks together, so I just kind of signed whatever she gave me.
Okay, so is it your testimony here today is that you were not aware of your bond conditions?
Well, not that one. I just know I wasn't, regular, not able to catch any extra charges or get in any more trouble and things like that.
Okay, so you were aware of some of the bond conditions, but you didn't read the very first one?
Right.
Okay. But you were aware that you weren't allowed to pick up any new offenses, correct?
Yes, ma'am.
Okay, and you were aware that you had a protective order against you, correct?
Yes, ma'am.
And that Alicia Hurd was the protected person in that protective order?
Yes, ma'am.
Okay. And you were aware that the conditions of the protective order were that you were not to have any contact with Alicia Hurd, correct?
Yes, ma'am. That's right.
And you still did attempt to contact her in multiple ways on July 31st of 2020.
Well, yeah, I was stuck in a bad position. We've been a
Okay,
team
but-
for a long time.
Mr. Hurd, in the protective order, you're aware that it doesn't state that you can contact Alicia even if you have an emergency, correct?
Yes.
It prohibits you from being in touch with Alicia for any reason and communicating with her in any manner, correct?
Yeah.
No further questions.
Anything else from the defendant?
No, Your Honor.
You rest.
We rest.
All right. Anything else from the state in rebuttal?
Just in close, Your Honor.
The argument?
Yes.
And we close too.
Judge, I don't think there's any argument that this defendant did not violate his bond conditions or violate terms of the protective order, thus picking up a new offense in the state of Texas. Defense's argument is basically that he had a good reason to contact her and he wasn't trying to be harassing or harmful. But at the end of the day, that doesn't matter because those bond conditions and the protective order, those are in place for a reason. Victims rely on those, and Alicia Hurd relies on that bond condition and those terms of the protective order that state that he is not allowed to be in contact with her. She has no idea why he is communicating with her. She doesn't know his intentions. She's not in his head. So to her, what she sees is multiple attempts to contact her over a short period of time in one night. And so for him to argue that they were good intentions, that's, he's allowed to make that argument, but at the same time, why have those bond conditions and that protective order in place if there are no consequences for that? Those conditions, they have to mean something for the protection of the victim. And it's the state's position that he should be held responsible for violating those terms and that his bond be held insufficient.
Your Honor.
Yep.
Yes, sir. I point out the protective order and the bond conditions do not prohibit my client from contacting Alicia's parents. And if Alicia chose to respond and return the call, that would not be a violation of the bond conditions because Alicia was the one who was instigating that. There were only 2 emails sent directly to Alicia. He never went to her residence. He never went to her place of employment. He was not threatening. This is the only time in 2 months that he has tried to contact her, and it was by email to borrow money to get his medications and get back into his hotel room. And I would argue that this is not sufficient to declare the bond insufficient. If he had gone to her employment, if he had gone to her residence, if he was harassing her or stalking her, we'd be in a different situation. But 2 emails, I don't believe are sufficient. And if the district attorney's office thinks that it is, then they can always file a new case. But I would argue that the evidence here is insufficient to hold the bond insufficient.
Anything else from the state?
Nothing further, Judge.
Mr. Hurd, I hope you understand you're not to contact her any way, shape, or form. I think that's been pointed out to you now. If you didn't understand it before, you know now. But I agree, the state, it's not sufficient to hold the bond insufficient. I'm not going to hold the bond insufficient this time. But understand clearly now you won't get another chance on this. So if you contact her any way, shape, or form, if you have an emergency, that's not her problem. You've got to deal with it some other way, okay?
Yes, sir.
The motion to hold bond insufficient is going to be denied.
Thank you, Your Honor.
Thank you all.
Thank you, Judge.
Sir.
Thank you, Molly.
Thank you, Mr. Steinke.